Hello everyone and welcome to Uncivil Law. For today's case, we have the case of Karen McNeil versus Giles County, Tennessee. In this case, we're talking about bail and the requirements of bail, and bail that is being set too high that people cannot pay it and therefore are being held in jail, even though they shouldn't be because they simply can't afford bail. And this is a problem in the United States, and we're going to learn about one such problem that occurred in Giles County, Tennessee, and how the Court of Appeals is being asked to adjudicate it. And so let's get started with this. Several criminal defendants believe the way Tennessee sets the amount of bail for misdemeanor crimes violates federal due process. Under Tennessee law, a county sheriff enforces probation violation warrants, and the bail amounts are established by state law and set by a local judge. The district court granted the probationers a preliminary injunction against the county and sheriff's enforcement of the bail requirements. The county and sheriff do not challenge the preliminary constitutional ruling. They argue for now only that the probationers should have sued the state judges who determine the amount of bails instead of suing the county and the sheriffs who enforce them. We affirm. So here the district court granted a preliminary injunction, which is, while the case is pending, it's not a permanent injunction, but, while the case is pending, granted a preliminary injunction that prevented them from enforcing certain of these things because of the unconstitutionality. The Court of Appeals is affirming and saying that, yes, the district court couldn't do this injunction, and they're going to discuss a little bit more as to why. Just one claim matters today. The probationers say the county and sheriff violated their substantive right against wealth-based detention by detaining them after arrest until they paid bail. The problems, say the probationers, is that judges set the bail amount without reference for a person's ability to pay, outside the person's presence, and without determining whether the person poses a danger to the community or a risk of flight. If a judge decides to set bail, Tennessee law requires that the amount be set as low as the court determines is necessary to reasonably assure the appearance of defendant as required. It also spells out the things the judge must consider in determining that amount, including how long the person has lived in the community, the prior criminal record, and financial condition. The first opportunity to convince a judge to lower bail takes a few weeks. General Sessions Court's arrestees receive their first court appearance within 10 to 14 days, but may not challenge the bail amounts until a second court appearance 10 to 14 days after the first. Circuit court arrestees appear in court on one designated day a month, meaning the county detain them for up to 30 days without a challenge to the bail amounts. So that is pretty interesting indeed, that it can take 30 days for a person to be able to challenge a bail amount that was set without them being present in the first place and was set without taking into consideration the factors. All these things do seem like violations of due process to my mind. You want this to be done much faster. You want it to be done in the presence, and you want it to be done with consideration of the factors. And so the fact that it's not being done here is problematic at minimum. Tennessee law suggests that Sheriff Helton acted for the state when he enforced the bail amounts. The Tennessee Constitution creates the office of the county sheriff. Therefore, the lawsuit may also proceed against the county for now. The county does not deny that it employs the sheriff, nor does it deny the sheriff's involvement in the child's detention, nor does it claim it acted against its commands when it detained the plaintiffs. The county, if it's true, may be able to raise defendants to this 1983 claim. It may be able to show, for example, that no constitutional violation occurred or that county policy or custom did not trigger it. But few considerations counsel against resolving that defense today. Don't break my heart, my achy breaky heart. Don't understand. If you break my heart, my achy breaky heart, might grow up and might. So that is the end of the case of Karen McNeil versus Giles County, Tennessee. In this case, we learn that in Giles County, judges are setting bail without proper consideration of the factors set out. They're not considering the ability to pay, and they're not considering the amount that will take need for the people being able to show up. It's disconnected. And if you want to challenge the bail amounts, you can't do so for 30 days, which seems like a due process violation. And so the preliminary injunction that prohibits the sheriffs from enforcing these orders is allowed to stand as further discovery goes forward into what actually occurred at the county, and that is the end of this story.